Strict liability and absolute liability, a lively outline. Introduction. Imagine you're hosting a barbecue in your backyard. You bring a huge helium tank to inflate balloons for decorations. The tank accidentally bursts, sending balloons and chaos into your neighbor's property, smashing their prized gnome collection. Now, you didn't mean for this to happen. You weren't negligent, you just wanted a festive atmosphere. Still, under the legal principle of strict liability, you might be held responsible. Why? Because you brought something potentially harmful, the helium tank, onto your land, and it caused damage when it escaped. This idea of holding someone accountable even without intentional wrongdoing originated in Rylands vs. Fletcher, 1868, a case that transformed English tort law and gave us the principle of strict liability. It's like the law saying, if you are playing with fire, or a giant water reservoir, you better make sure it doesn't hurt anyone else. Principle of strict liability. The case of Rylands vs. Fletcher. Let's rewind to the 1800s. Imagine two neighbors, one builds a massive reservoir on their land. But oops, something goes wrong, and water floods the other neighbor's property. The court ruled that, greater than if you bring something likely to cause harm onto your land and it escapes, you're responsible for the damage, unless the other guy caused it, or it was due to an act of God, like a freak tornado. The judge basically said, if you are going to bring a dangerous thing to your party, don't let it crash someone else's. Essential ingredients of strict liability. 1. A dangerous thing. This isn't about your pet goldfish escaping, it's about something inherently risky, like chemicals, wild animals, or helium tanks. If it escapes, it spells trouble. 2. Escape. For liability to stick, the dangerous thing must leave your property. If the helium tank bursts but stays in your yard, it's your headache, not your neighbor's. 3. Non-natural use of land. If you are using your land for something unusual, like building a rocket launch pad, it's considered non-natural. This is key to strict liability. Exceptions to the rule. Even strict liability has its get-out-of-jail-free cards. 1. Act of God, Nichols vs. Marsland. If a freak storm or earthquake caused the helium tank to explode, you might not be liable. The law says, Mother Nature. Not your fault. 2. Act of a third party, Box vs. Jab. If your nosy neighbor fiddles with your helium tank and causes the mess, it's on them. 3. Plaintiff's consent, Caster vs. Taylor. If the neighbor knew about your helium tank and said, cool, go ahead, they can't later complain when things go wrong. 4. Plaintiff's own default, Ponting vs. Noakes. If the neighbor kicks the helium tank over themselves, they can't sue you for their own mistake. 5. Statutory authority, Green vs. Chelsea Waterworks Company. If you're legally required to keep that helium tank, the law might let you off the hook. Beyond. Fast forward to modern India, where MC Mehta vs. Union of India, 1987, redefined the game. The court said, if you're running a hazardous activity and it causes harm, you're liable. Period. No excuses. This is called absolute liability, and it's like strict liability's no-nonsense cousin. The idea is that if you profit from risky activities, you must compensate anyone harmed, whether or not you are at fault. In short, the law doesn't care how careful you are. If you are playing with dangerous toys, you pay for the damages. No exceptions. Real-world applications. From motor vehicle accidents to chemical plant disasters, remember the Bhopal gas tragedy. These principles ensure that victims aren't left hanging, and in India, the Public Liability Insurance Act, 1991 mandates companies handling hazardous materials to take out insurance, ensuring victims get relief without long legal battles. So, the next time you think of bringing a helium tank, or a crocodile, onto your property, remember, the law is watching.